Across the United States right now, your bank is quietly sending information about your cash deposits to the federal government, and most account holders do not know it is happening today. If you send money home to family members every single month, if you have ever broken one large deposit into smaller pieces to avoid paperwork at the teller window, if you currently rely on a money transfer app to move dollars across an international border, this update affects you immediately today. The first consequence is a frozen bank account that locks you out of your own paycheck overnight today. The second consequence is an Internal Revenue Service audit that demands years of proof for money you thought was private today. The third consequence is a delayed or denied green card renewal because your bank pattern did not match your income on file under immigration law now. The fourth consequence is a citizenship interview where an officer asks where every dollar came from and where every dollar went under oath today. This is not a rumor from social media, and it is not a viral post from a stranger on your feed today. The information comes from a federal statute on the books since 1970, plus new enforcement rules that began January 1st of 2026 today. If you walk away before I finish, you may leave without the $1 figure that decides whether your account gets flagged today. Let me explain this in the plainest English I can, because this part matters more than people realize today. The rule the federal government is using right now is not some brand new law. Congress did not pass it last week. The actual law behind this enforcement is called the Bank Secrecy Act. That law was signed by President Richard Nixon all the way back in 1970. The Bank Secrecy Act sits inside Title 31 of the United States Code. The specific section that does most of the daily work is 31 U.S.C. Section 5313. Section 5313 requires every bank in America to file a form called a Currency Transaction Report, also called a CTR. That CTR must be filed for any cash deposit, withdrawal, or transfer of $10,000 or more that happens inside a single business day. The penalty for not filing that form falls on the bank itself. The form itself goes straight to the Financial Crimes Enforcement Network, also called FinCEN. FinCEN is the federal bureau that sits inside the United States Treasury Department today, so the law itself has been on the books for 56 years today. The enforcement side of that law, however, changed dramatically on January 1st of 2026. That is the day FinCEN turned on a brand new data sharing pipeline with the Department of Homeland Security, also called DHS now. That data sharing pipeline is the part that is genuinely new in 2026. Here is what most people do not realize about the Bank Secrecy Act, and this is the part that catches immigrants by surprise today. The Bank Secrecy Act is also the law that creates 31 U.S.C. Section 5324. Section 5324 is the federal anti-structuring statute still in force today. That section makes it a federal crime to break one transaction into smaller pieces on purpose to dodge the $10,000 cash reporting rule. The maximum penalty under Section 5324 is 10 years in federal prison and a fine of up to $500,000 today. So even if you never deposit $10,000 in cash at one time, you can still violate Section 5313 today. The pattern of smaller deposits is the violation now. That is the trap people walk into without realizing it. Now here is the dollar number that surprises almost every single senior I have ever talked to today. Most people assume the Bank Secrecy Act catches them only if they deposit more than $10,000 in cash. They assume this happens at one branch on one single day. That assumption is wrong today. The real number that triggers a federal file on your account is much smaller than $10,000 in 2026. The actual trigger number inside the new FinCEN pipeline is $5,000 in a single suspicious-looking transaction today. The second trigger number is $3,000 in a pattern of related transactions across 1 week today. When a bank sees a cash deposit of $5,000 or more that does not match your normal account behavior, the bank must file a suspicious activity report, also called a SAR today. That SAR goes to FinCEN right alongside the traditional CTR today. The $5,000 SAR threshold is almost never explained to ordinary account holders today. Most bank employees themselves do not volunteer that number at the teller window now. So here is what that means in your kitchen today. A $1,400 cash deposit from your daughter's birthday gift can become part of a SAR file today. A $900 cash deposit from selling your old car to a neighbor can be added to that same SAR file now. A $1,700 cash deposit from a yard sale can become the third line on the same federal report today. None of those individual deposits cross $10,000 now. None of those individual deposits would have triggered a federal report on their own under the old rule today, but FinCEN added them all together into one combined SAR file under the new 2026 rule today. That SAR file is now sitting in a federal database in 2026 right now. The new $5,000 trigger number is the dollar amount most people do not know about at all today. The new $3,000 trigger number is the dollar amount your banker may not even mention to you now. Both numbers came from FinCEN rule updates that became effective January 1st of 2026. And that is exactly why a 68-year-old grandmother in Ohio with a totally clean record can suddenly have a federal file on her savings account today. Now let me walk you through exactly how that SAR file travels from your bank branch all the way to your immigration file in 2026. I want to do this step by step in plain English. Step 1 happens inside the bank itself today. When you walk up to the teller window with $5,000 in cash for any reason, or when you make several cash deposits that together total $3,000 to $5,000 across a single week, the bank's anti-money laundering software automatically flags your transaction today. That flag happens before you even leave the lobby now. Step 2 happens inside FinCEN within 72 hours today. The bank uploads your flagged activity as a suspicious activity report into the FinCEN database today. That database is also called the BSA database. The legal authority for this upload is 31 U.S.C. Section 5318G today. Step 3 is where things get very serious for immigrants in 2026. Under the new data sharing agreement that took effect January 1st of 2026, FinCEN automatically forwards certain SAR files to the Department of Homeland Security today. DHS contains 3 separate agencies that each touch a different piece of your immigration file today. The first agency is United States Citizenship and Immigration Services, also called USCIS today. USCIS handles green cards, citizenship applications, and family-sponsored visas in 2026. The second agency is Immigration and Customs Enforcement, also called ICE now. ICE handles removal proceedings, detention cases, and supervised release today. The third agency is Customs and Border Protection, also called CBP today. CBP handles the moment you physically cross the border into the United States in 2026. Step 4 happens inside USCIS itself today. When you file Form I-485 to adjust status, or Form I-130 to sponsor a relative, or Form N-400 to apply for citizenship, USCIS now cross-references your income tax transcripts against the SAR pattern files today. The internal reference memo for that cross-reference is USCIS-2026-FinCEN-014 today. Step 5 is where the Social Security Administration, also called SSA, becomes involved in 2026. SSA receives its own data feed directly from FinCEN under a separate Memorandum of Understanding signed in late 2025 today. SSA uses that feed to flag supplemental security income cases. Those cases are also called SSI cases. An SSI case can be flagged when the recipient's bank pattern does not match the recipient's reported income today. Step 6 is where your federal income tax transcript enters the picture now. The Internal Revenue Service, also called IRS, has its own direct feed into the same FinCEN database today. The legal authority for that feed is 31 U.S.C. Section 5311 today. So your Form 1040, your Form 1099, and your FBAR filing all end up sitting in the same federal file as your SAR history in 2026 today. The trigger for any of these federal agencies to open a closer look is not the dollar amount today. The trigger is the mismatch between what you reported and what your bank told FinCEN now. So even a hardworking senior with a 30-year clean record can land in this federal review pipeline today. That happens if her $42,000 a year salary does not match her $50,000 a year bank deposits in 2026 today. That mismatch is what flags the file under the new 2026 rule. That mismatch is what makes the file travel from FinCEN to USCIS today. Let me introduce you to a real person now, because abstract federal statutes do not hit your heart the same way a real human name does today. Her name is Maria today. Maria is a lawful permanent resident from El Salvador today. Maria works as a certified nursing assistant in Houston, Texas today. Maria has held her green card since 2018 today. Maria files her federal income tax return every single April without fail now. Maria earns about $42,000 a year at her nursing job today. Maria also sends roughly $800 home to her mother in San Salvador every single month today. Maria uses a major money transfer app because the transfer fee is lower than the wire fee at the bank downtown today. Maria's remittance pattern has been almost identical for 5 straight years now. She sends $800 on the 5th day of every month to her mother today. Maria's monthly income is roughly $3,500 after federal taxes are taken out today. Maria's $800 monthly remittance is about 23% of her take-home pay in 2026 now. Maria also deposits the remaining $2,700 into her checking account at the bank to pay rent to her landlord on the 1st of each month today. Here is where the new 2026 rule touches Maria's life in a very direct way today. Under the old federal enforcement style that ran before 2026, Maria's banking pattern would never have triggered a federal file at all today. Maria never crossed $10,000 in cash in one single business day now. Maria never crossed $5,000 in a single cash deposit today. Maria's $800 monthly remittance is below every CTR threshold that has been public since 1970 today. But under the new FinCEN rule that turned on January 1st of 2026, Maria's repeated $2,700 deposits look structurally unusual to the bank's anti-money laundering software now. The bank's software sees that 23% of her take-home pay is leaving the country in fixed monthly chunks today. The software sees that the same recipient name appears on the same day of every month in 2026 now. The software flags Maria's account as a behavioral pattern match under the new 2026 rule today. ASAR is automatically filed on Maria today. Maria has done absolutely nothing wrong now. Maria is a hard-working, tax-paying, family-supporting lawful permanent resident today. That SAR enters the FinCEN pipeline now. From there, that SAR can be cross-referenced against Maria's pending Form 1751 petition to remove the conditions on her second-year green card today. From there, that SAR can be cross-referenced against Maria's mother-in-law's pending Form Y130 family sponsorship application in 2026 now. From there, that SAR can appear in front of the USCIS officer reviewing Maria's naturalization file when Maria applies for U.S. citizenship in 2027 today. Maria did not commit a single crime today. Maria simply made 100 normal monthly deposits and remittances the way millions of hardworking immigrants do today. And yet Maria now has a federal behavioral pattern match sitting next to her green card file because of the new 2026 enforcement rule today. Now let me introduce you to a second person today, because Maria's case alone does not show you how wide this federal net really is in 2026. His name is Rajiv today. Rajiv is an H-1B specialty occupation visa holder from India today. Rajiv works as a senior software engineer in San Jose, California today. Rajiv has been on H-1B status since 2019 today. Rajiv's base salary is $135,000 a year today. His yearly performance bonus pushes his total annual compensation closer to $160,000 in 2026 now. Rajiv sends roughly $2,500 home to his parents in Hyderabad every single month today. Rajiv also wires roughly $15,000 a year extra to his parents in December today. That December wire helps his parents cover medical costs for his father in 2026 now. Rajiv's monthly deposit pattern at his bank is much larger than Maria's monthly pattern today. Rajiv's checking account typically runs a balance between $40,000 and $70,000 because Rajiv saves aggressively for a future home purchase now. Rajiv's monthly wire transfer of $2,500 to his parents in Hyderabad has been almost identical for 4 straight years today. Rajiv's December annual transfer of $15,000 has been almost identical for 4 straight years in 2026 now. Rajiv is currently sponsoring both of his parents for a family-based green card through Form Y-130 today. The estimated wait time for that case is 8 to 12 years, given the current visa bulletin backlogs for India in 2026 today. Rajiv's family-based case is currently sitting at the National Visa Center, also called the NVC, today. Rajiv's NVC case number is NVC-2026-HYB-7782 today. Here is where the new 2026 federal rule touches Rajiv's life in a quite different way than it touched Maria's life today. Because Rajiv's monthly remittance is large enough to be reported as a recurring international wire pattern today, the bank's software now flags the $2,500 wire each month because that recurring wire crosses a wire pattern threshold under the new 2026 enforcement rule in 2026 now. The bank's software also flags the $15,000 December wire because that annual amount exceeds the Form 8300 reporting threshold for any single recurring transaction that runs through a financial institution today. Form 8300 used to apply mostly to cash-based businesses, not bank wires, but the new 2026 rule expanded Form 8300 reporting to certain wire patterns as of January 1st today. Rajiv did not know that rule change existed today. Rajiv had never even heard of Form 8300 before he watched this video in 2026 now. Rajiv assumed his H-1B salary made his financial pattern obvious and clean to the federal government in 2026 today. But Rajiv's pattern now looks concentrated on a single recipient to the bank's anti-money laundering software today. That software files a SAR on Rajiv now. From there, that SAR can be cross-referenced against Rajiv's Form Y-130 for his parents today. From there, that SAR can be cross-referenced against Rajiv's own H-1B extension case when Rajiv files Form Y-129 in 2027 now. From there, that SAR can follow Rajiv straight into his own green card adjustment case under INA Section 245 today. That case will activate when an immigrant visa number finally becomes available for his parents in 2026 now. And Rajiv's December $15,000 wire, plus 20 years of H-1B status, plus the same recipient name on the same date, may also add up to a pattern of foreign resource transfers review under an internal memo that the United States Department of State issued on February 14th of 2026 today. Rajiv did not commit even a single federal crime today. Rajiv simply supported his aging parents in the way his culture expects him to support them today. And Rajiv now has a federal SAR file sitting next to his parents' sponsorship case in 2026 today. Here is the part that should scare the calmest grandmother in America today, because this is where federal law truly turns the table on the immigrant applicant. In a regular criminal court in the United States, the federal government must prove that you are guilty beyond a reasonable doubt today. That is how American criminal law has always worked in 2026. But in U.S. immigration court, the burden of proof sits on the applicant, not on the government today. INA Section 240, which is also called the Immigration and Nationality Act, Section 240, says the applicant has the legal duty to prove that they are admissible today. INA Section 245 says the adjustment of status applicant must prove that they are eligible for that benefit today. INA Section 316 says the naturalization applicant must prove that they have maintained continuous residence and good moral character for the required statutory window today. That legal phrase, good moral character, is the hidden trapdoor inside immigration law today. Good moral character includes a financial dimension across the entire application file. That financial dimension includes whether your bank deposit pattern matches your stated income on file today. So when Maria's SAR file enters the same federal database as her Form N-400 application for U.S. citizenship, the legal burden is on Maria to explain every flagged line item deposit today. When Rajiv's SAR file enters the same federal database as his parents' Form 1130 family sponsorship application, the legal burden is on Rajiv to explain every flagged recurring wire today. The federal government does not have to prove that Maria did anything illegal today. The federal government does not have to prove that Rajiv did anything illegal today. Maria and Rajiv must prove that they did everything legal under the new rule in 2026 now. That is a very different legal world from regular American criminal court today, and this is the world the new 2026 enforcement push is quietly creating for tens of millions of immigrants and their family members now. Maria does not get a free government-appointed lawyer today. Rajiv does not get a free government-appointed lawyer today. They both have to hire one, pay by the hour, walk into the local USCIS field office, and explain their financial lives line by line from documents they may have lost in a recent move. And the USCIS officer reviewing their file is not bound by any particular outcome today. The officer can issue a request for additional evidence, also called an RFE. That RFE then pauses the entire pending immigration case for 90 days or even longer in 2026 now. If the applicant cannot produce the requested financial documents inside that 90-day window, the immigration case can be denied by the officer today. So a single SAR entry can buy a denied green card case today. A single SAR entry can buy a delayed citizenship interview now. A single SAR entry can buy an entire family sponsorship case paused for years on end today. That math is brutal, and that math is what most immigrant families do not see until the official-looking letter actually arrives in the mailbox today. Here is exactly what is happening right now in your community that should make every senior immigrant angry at the people who are taking advantage of them today. Across the United States, a wave of predatory consultants and unlicensed notarios are flooding immigrant neighborhoods with fear-based advertisements in 2026 today. Those ads often show up on Spanish-language radio, on Punjabi-language podcasts, on Mandarin-language social media groups, and on flyers posted outside the entrances of churches and temples today. The ads say scary things like, "The IRS is freezing all remittances today." The ads say scary things like, "The federal government is taking money directly out of immigrant bank accounts today." The ads say scary things like, "You must move every dollar into a private trust before December 31st of 2026 today." None of those statements are technically true under the actual 2026 federal rule today. But the fear is real, and the fear is what the predators use to charge $3,000, $5,000, even $10,000 upfront for emergency immigration tax help today. Here is how the typical scam actually runs in 2026 right now. An unlicensed notario approaches a senior who recently received an inquiry letter from the bank asking about unusually large cash deposits today. The notario invites the senior to a so-called free consultation in the back room of a tax preparation storefront today. That consultation lasts about 20 minutes on the stopwatch today. The notario then tells the senior that the senior must structurally protect the senior's bank money today. The notario says the protection comes from moving the money into a private trust account held by the notario's own office today. The senior, who is afraid, hands over direct access to the bank account today. The notario then files a series of suspicious-looking reports on the senior's behalf to supposedly preempt an Internal Revenue Service audit in 2026 now. The notario charges the senior a one-time fee of $7,500 today. The notario also charges monthly custodial fees for the supposed trust account today. The senior's name ends up in a worse federal database than before today. The senior's bank accounts may now actually be flagged under 31 U.S.C. Section 5324 for real federal structuring in 2026 today. And the notario walks away with the senior's entire life savings today. This exact pattern is now showing up in at least 7 different states, according to a consumer alert report issued by the Federal Trade Commission in February of 2026 today. The 7 states with the highest number of reports are California, Texas, Florida, New York, Illinois, Georgia, and North Carolina today. Those 7 states match the 7 states with the largest documented immigrant populations in 2026 now. None of those notarios are licensed immigration attorneys today. None of those notarios are licensed tax professionals in 2026 today. Most of them cannot even lawfully appear in your place before a USCIS officer at any field office today. The only people who can legally represent you before USCIS in 2026 are licensed attorneys in good standing, accredited representatives who appear on the Department of Justice's recognition and accreditation list, and certain recognized organizations in 2026 today. Everyone else is a salesperson at best today. Some of them are outright criminals today. So here are 7 specific actions you should take right now today. I am going to recite these out loud like a friend telling a slightly confused parent what to do this morning in 2026. Action number 1. Open a U.S. bank account in your own legal name today. Then stop using cash-based mobile apps for large international transfers right now today. Action number 2. Keep a simple handwritten paper ledger on your kitchen table today. Write down every single dollar you send abroad and every single dollar you receive from abroad today. Put the calendar date, the recipient full name, and the exact dollar amount in US dollars on every single line of that ledger today. Action number 3. File the FBAR, which is officially called FinCEN Form 114, if any one of your foreign financial accounts held more than $10,000 at any single point during calendar year 2026 today. The FBAR deadline is April 15th of 2027. The FBAR has an automatic extension all the way out to October 15th of 2027 today. Action number 4. Never break one large payment into smaller pieces to avoid a bank teller flag today. That behavior is exactly what 31 U.S.C. Section 5324 calls federal structuring. The maximum federal penalty is up to 10 years in federal prison and a fine of up to $500,000 today. Action number 5. Keep printed paper proof of the original source of every deposit over $1,000 today. This is especially important for deposits that come from family member gifts sent from abroad today. Because when a SAR file lands next to your immigration case file, the USCIS officer will politely ask you where the money came from today. You will need an answer that is one clean piece of paper or one well-organized paper folder. Action number 6. Save every single money transfer receipt in a single physical accordion folder on your desk today. Sort those receipts by calendar month today. Put the date, the dollar amount, the recipient full name, and the transfer reference number on every receipt today. Because that folded paper folder is the difference between a smooth naturalization interview and a long denial letter in 2026. Action number 7. Talk to a licensed immigration attorney before you renew your green card today. Talk to a licensed immigration attorney before you sponsor any family member today. Talk to a licensed immigration attorney before you apply for U.S. naturalization today. Talk to a licensed immigration attorney before you file any H-1B extension today. And talk to a licensed immigration attorney before you accept any cash or wire gift of $5,000 or more from a relative located abroad today. The cost of that 1-hour consultation is genuinely small compared to the cost of a denied immigration case today. Those are your 7 specific actions right now today. Print this list on your home printer if you have to today. Read the list aloud to a trusted friend if you need to today. Tape the printed list to your refrigerator door so you cannot accidentally lose it today. The goal here is not to make you feel scared forever today. The goal here is to make you prepared exactly once right now today. And here is a quiet bonus piece of advice I want you to remember. The single biggest mistake I see seniors making in 2026 is mixing immigrant family money with undocumented cash side work today. If your son-in-law pays you in unrecorded cash for babysitting, and you deposit that same cash into the same bank account where your monthly Social Security check lands, the SAR software reads the whole single account as one combined money pattern today. The Internal Revenue Service reads the whole single account as one combined income source today. United States Citizenship and Immigration Services reads the whole single account as the financial foundation of your entire family immigration case today. So action number 8, the bonus action today, is this. Open a second separate simple low-fee savings account at the very same bank branch today. Put all of your properly documented income into your main checking account today. Put all of your small documented cash gifts into the second separate savings account today. Then keep a separate paper ledger of the second account inside a single clearly labeled manila folder today. That is how you keep your bank pattern plain and readable to the federal software today. That is how you keep your immigration case plain and readable to the USCIS officer who will eventually review it today.